Alright, folks, as I said, there was two documents filed. I already put out the response that Netflix gave, but here's the other document that was filed on the same day. United States State District Court for Eastern District of Wisconsin, the Andrew Colborn versus Netflix, answered the second amended complaint. Defendants, Crow Media, Synthesis Films, Laura Riccardi, and Maura Demos collectively answered the second amendment complaint of Andrew Colborn as follows, paragraph by paragraph, and using headings used by plaintiff, but without admitting any allegations contained into those headings as follows. The producer-defendants stand behind the documentary series Making a Murder, which objectively and accurately conveys viewpoints, contingents, and experiences of those portrayed in the series. The series, in part, concerns Stephen Avery and Brendan Dassey's arrests and convictions for Teresa Halbach's murder, but it is not until more than halfway through the second episode that Teresa Halbach is reported missing. Before that point, the series documents range of Stephen Avery's experience in the legal and political systems, including his 1985 wrongful conviction, his appellate and post-conviction efforts, his 2003 exoneration, Wisconsin Attorney General's investigation into the wrongful conviction, the Avery Task Force, and Avery's federal civil rights lawsuits against Manitowoc County and two of the former law enforcement officials. Once the series began to chronicle the Halbach case, the producer-defendants filmed events as they were unfolding in observatorial documentary style, where neither the filmmakers nor the subjects knew what would happen next. The filmmakers will also conduct sit-down interviews with subjects regarding those events. When editing this part of the series, the producer-defendants chose to lay out the story in a presented tense without voiceover narration of the filmmakers or anyone else. The result is that the events play out as people on all sides of the Halbach case take action, voice their points of view, and make their respected legal arguments concerning Halbach and her horrific murder, as well as the investigation, prosecution, conviction, and sentencing of Avery and Dassey in appellate and post-conviction phases of those cases. In producing the series, producer-defendants sought access to individuals with first-hand knowledge. Untimely, they would not control who decided or was permitted to sit down with them for interviews, and so were only partially successful in gaining direct access to subjects. But for subjects who did not participate, the filmmakers included the voices, perspectives, and points of views of those individuals, including Andrew Colborn, through the use of footage that captured in public spaces as well as primary source and other third-party materials. The series was devoid by the bias by design. Produced defendants intend to raise questions by deliberately did not provide answers or tell their viewers what to think. Colborn suggested that the contrary fundamentally misconstrue Making a Murder. In truth, the producer-defendants presented their viewers with a myriad of experiences and viewpoints in a tapestry that educates those viewers about the complexity of matters like those presented in Making a Murder, and the value accepting ambiguity rather than demanding certainty. Of course, while Making a Murder is a non-fiction, it is indisputable that the process of making a documentary necessarily requires editing. This involves summarizing, condensing, and compressing a substantial volume of information. Indeed, Stephen Avery's 2007 trial lasted 5 weeks, and part 1 of Making a Murder series spent less than 3 hours of its running time in the courtroom for Avery's trial. At the trial, plaintiff himself was on the stand for just over 3 hours, yet in part 1 of the series appeared on the stand for just over 10 minutes. Cumulatively among all 10 episodes, simply put, I would have to been impossible to include everything. The producer-defendants here not alter the meaning of events, including the components of the series to relate to plaintiff Andrew Colborn, as well as Stephen Avery's defense theories and strategies. Parties. The producer-defendants admit that Colborn is an adult, but presently lacks sufficient knowledge of information to form a belief as to the truth of the remaining allegations in paragraph 1, and the bias deny them. The producer-defendants presently lack sufficient knowledge of information from a belief as to the truth. The allegations, paragraph 2, and the bias deny them. Producer defendants admit that Crow Media is in New York, but deny that Venture Boulevard, California, was ever Crow Media's place of business, let alone principal place of business. Producer defendants admit allegations in paragraph 5, paragraph 6, paragraph 7. Producer defendants admit that Lord Cardi and Lord Demos have ownership interest in Crow Media, formerly known as Synthesis. I can't talk right now, sorry. Producer defendants admit that they are created as, among other things, executive producers of the Making a Murder Part 1 and Making a Murder Part 2, and producer defendants admit that Riccardi and Demos participated in camera pool for filming of the trial. The producer defendants deny remaining allegations in paragraph 8. Statement of the facts. Producer defendants presently lack sufficient knowledge and information from belief the truth of allegations in paragraph 9, paragraph 10, paragraph 11, paragraph 12, and on the basis deny them. Producer defendants admit that Teresa Halbach, who was a 25-year-old freelance photographer, was murdered on October 31st, 2005. The producer defendants likewise admit that Stephen Avery and Brendan Dassey were convicted for Halbach murder, and that those convictions are presently unreversed, although there remain ongoing legal proceedings, at least with respect to Avery. Expecta expressly admitted the producer defendants presently lack sufficient knowledge of information to form a belief in the truth of the remaining allegations of paragraph 13, and on the basis deny them. Producer defendants admit that Stephen Avery was wrongfully convicted of first-degree sexual assault, false imprisonment, and attempted first-degree murder in 1985. The producer defendants further admit that Avery served 18 years of a 32-year prison sentence before he was released after DNA evidence exonerated him and inculpated another, Gregory Allen. Except as expressly admitted, the producer defendants presently lack sufficient knowledge of information to form belief the truth of the remaining allegations in paragraph 14, and on that basis deny them. The producer defendants admit that Making Murder was and continues to be marketed as in fact is, a non-fiction documentary that reflects on an accurate, unbiased, and objective representation of viewpoints, contentions, and experiences of those portrayed in the series. Producer defendants further admit that none of the 10 episodes of Making Murder Part 1 contained disclaimer, but deny that such disclaimer was necessary or appropriate. Producer defendants admit that they won multiple awards for Making a Murder, including Emmy Awards, Outstanding Directing for a Non-Fiction Program for Episode 10, and Outstanding Writing for a Non-Fiction Program for Episode 1. In 2017, Cinema Honors awarded Outstanding Achievements in Non-Fiction Films Made for Television, except that it expressly admitted the producer defendants presently lack sufficient knowledge or information to form a belief as to the truth allegation in paragraph 17 and the basis deny them. The producer defendants deny the only materials that Demos and Riccardi had been pitched Making a Murder on Netflix were 3 episodes in rough cut. Producer defendants presently lack sufficient knowledge of information to form belief as to the truth of the remaining allegations, paragraph 18, and on that basis deny them. Producer defendants deny allegations in paragraph 19. Producer defendants deny allegation 20. And producer defendants admit that Exhibit A purports to contain excerpts of a transcript to Making a Murder, episode 1 through 10, but deny those excerpts accurately portray Making a Murder series. The producer defendants deny remaining allegations in paragraph 21. 1994 and 1995 telephone call, subsequent alleged cover-up. Producer defendants admit that Exhibit B purports to contain excerpts of the transcript of Amber Coleman's trial testimony, but deny that Exhibit B is accurate. Producer defendants deny the remains allegations in paragraph 22. They deny paragraph 23. Producer defendants presently lack sufficient knowledge of information for belief is truth of the allegation in paragraph 24, and on this basis deny them. The producer defendants presently lack sufficient knowledge of the information from belief is truth of the allegation in paragraph 25, deny it. Also, paragraph 26, paragraph 27, and producer defendants admit that Stephen Glenn appears in making a murder series, which speaks for itself. The producer defendants otherwise deny allegations in paragraph 28. Producer defendants admit they review sworn deposition transcripts from Stephen Avery's wrongful conviction lawsuit, except as expressly admitted. The producer defendants deny allegation 29. Plaintiff's call of dispatch. The producer defendants presently lack sufficient knowledge of the information from belief that the truth of the allegation in paragraph 30, and on this basis deny him. They also deny paragraph 31, 32, 33, all the way up to 37. The producer defendants admit that Ricardo Demos participated in the camera pool for filming the trial. The producer defendants presently lack sufficient knowledge of information from the belief to the truth of the allegations that in the truth plaintiff did not discover Hellbox US SUV as another location to help them others plant Avery's property. On their bias deny them, producer defendants deny the remaining allegations. Producer defendants admit that they produced making a murder series, which speaks for itself. They also deny allegations in paragraph 39. Producer defendants admit that they produced the Making Murder series, which for itself and the intended Stephen Avery child entirely. Producer defendants presently lack sufficient knowledge and information from a belief as to the truth of the allegation in paragraph 40. Producer defendants otherwise deny allegations in paragraph 40. Producer defendants deny allegations in paragraph 41, the key. They also deny paragraph 42, 43, 44, 45. They're not fessing up to anything. They just want to get the lawsuit dropped, basically. MAB's omission distorts the material sequence evidence of facts. Producers deny allegations in paragraph 46, 47, 48. Producers deny Making Murder 2 was released for purchase. The producer defendants admit that Ricardo Demos wrote and directed Making a Murder Part 2. The producer defendants admit that Netflix provided marketing and distribution for Making Murder 2. Producer defendants deny remaining allegations in paragraph 49. The extent Lord Riccardi and Moore Demos gave an interview that is or made comments that are available publicly, those statements speak for themselves when they're proper context. To the extent paragraph 50 contains factual allegations that require an answer, producer defendants deny those allegations. Producer defendants deny allegations in paragraph 51. Basically, it's deny. Claim of relief. Producer defendants incorporate and restate their responses set forth in the preceding paragraphs of the answer 58, 59, 60, 61. The producer defendants presently lack sufficient knowledge of information from a belief as to truth allegations concerning Netflix viewership numbers. Producer and defendants deny remaining allegations. 63, 64, 65, 66, 67. Negligence count 2. Pursuant to court's May 26, 2021 order granting in part and denying in part the defense motion to dismiss, producer defendants not respond to the negligence claims in the Second Amendment, May 26. This is just going over everything that took place up until where we are now. Granting part, denying motions. Intentional inflection and emotional distress. Producer defendants incorporate restate the response set forth in the proceedings paragraphs of the answer 78, 79, 80, 81, and 82. Affirmative defenses. Producer defendants allege that the following additional affirmative defenses in response to allegation in this act. Producer defendants reserve the right to amend this answer and these defenses. The producer defendants do not in any way agree to concede or burden proof for pursuing of any of these issues. The SAC at each claim alleged therein that against producer defendants fails to state a claim on which relief can be granted. Plaintiff SAC buried in whole as part of the First and Fourth Amendments. Barred in whole in part because of the challenge statements are not of and concerning the plaintiff. Barred in whole because of challenge statements not necessarily capable of defamatory meanings. Barred because a part of the challenge statements non-actionable under the subsidiary meaning doctrine. Barred in whole in part because of all the challenge statements non-actionable under the First Amendment. Barred in whole because some of all of All of the challenge statements are non-actionable under the First Amendment, Wisconsin and California. Barred and hold because the doctrine of fair comment, true privilege, and Wisconsin and California Civil Code section. Barred because the doctrine and neutral reportage. Barred and hold part of applicable state statute of limitations. Barred and hold and part of the doctrine is the lax, waiver, estoppel, unclean hands, and any combination thereof. Barred and hold in part plaintiff's willful misconduct. Barred and hold in part because the court does not have personal jurisdiction over the producer defendants. Barred and hold is part of the single publication rule in California Civil Code. Barred and hold because the plaintiff's act does not assert verifiable false statements implicating the facts of the producer defendants. Also, in whole and part because the producer defendants conduct reasonable, justified, good faith, done with non-willful and innocent intent at all times. Barred and whole because distributed about a matter of public interest concerned without actual malice or will. Also in whole or part because plaintiff is not alleged special damages with sufficient particularity and cannot prove the special damages. Part because of the incremental harm doctrine. Barred and whole and part of the extent that this act arises from conduct of the non-attributable producer defendants, and any recovery by plaintiffs should be reduced to proportion to the fault of others. Barred and whole in part because without admitting the plaintiffs entitled to any recovery to which plaintiffs entitled must be reduced by reason of plaintiff's failure to mitigate his damages, if any. Not entitled to recover any punitive damages because act and each cause of action caused against the producer defendants therein, each of relief sought there fails to plead facts sufficient to support the recovery of punitive damages. Plaintiff is not entitled to recover any punitive damages because such award would violate producer defendants' right to due process and equal protection under the state laws and Wisconsin and California and the United States. Each action the producer defendants therein and each form of relief sought therein, barred and whole and part of doctrine and consent. Barred and whole in part because the producer defendants alleged conduct with justified privilege under the circumstances. Plaintiff's act is barred and whole in part to the extent the plaintiff assumed the risk of alleged injuries or damages. Plaintiff's third claim barred because of impressible attempts to end the requirement to liable, labeling his claims intentional infliction of emotional distress. Signed, Kevin Lick and James Friedman, on the date of June 18th, 2021. So once we get another update, I'll bring it to you guys. So, see y'all next time.